All right, good evening, folks. Welcome to Monday Night Law with the new year, January 1st, 2024. How's everybody doing out there? We enjoying the new year yet? It's crazy time. It is a new year, yep. So, I'm going to be going over, kind of picking up where I left off a couple weeks ago with the absolute rights from Blackstone's Commentaries on the Law of England. Um, there's a few things kind of like to talk about. First, as something recent here, is Florida. Florida decided to supposedly pass a law that requires everybody the public servants, to do full disclosure of their financials. And apparently, um, many of the people have resigned in Florida, and it was supposed to come effective as of today. So, I don't know. What a wonderful thing going on in Florida. What an idea. Full disclosure of all your financials and where it comes from, right? Hmm. Uh, way to drain the swamp there in Florida. So, just that little tidbit there, something going on that has a profound effect. And think about that. What does that actually do? Hmm. Full disclosure of your financials. If you're receiving, funds from, say, George Soros or, um, any kind of, like here in Idaho, we have IACI, and we have all sorts of people who donate to elected officials to get their way with certain things. That would show up in your financial records. And so requiring a full disclosure there, that might that might get rid of a lot of public servants that are on the take. And why Florida? Isn't that where Trump is at? Interesting that this is starting in Florida. I think it should be a requirement nationwide. Full disclosure of your finances. Because what some of the things that's been talked about is certain public servants get into office, and they're only worth this certain amount. And then as they go, have been in office for a certain amount of years, now all of a sudden they're worth millions. How's that? How's that even possible on the salary that they receive, their annual salary? But it would be impossible. So, I wonder what's up with that. wonder if that's working out there on Facebook. I'm not seeing any of the Facebook Live. And is it working on Rumble? Okay, it is. Good. And the last time it didn't work on Rumble, and I don't know if I just got something mixed up there. Thank you, Alan Parrish out there on Facebook. Happy New Year to you, brother. Scott Rector, I haven't seen you in ages. What's happening, brother? YouTube. Yeah. And thank you over here, Jack Shot on Rumble for the 5x5 for audio check over there. Thank you, thank you. It is working over there, so that's good. And of course, over here on Telegram, I believe it's working. I can actually see that one working. And there's a couple comments already. So, yeah, you know, this is the start of a new year, especially for in Florida. Draining the swamp, right? We'll just require everybody to give full disclosure of all their finances and look at them drop like flies. Resign, 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 resign. And this is statewide. All public servants, all elected officials. So, if you don't have anything to hide, why are you resigning? Good to see some of my regular people here from Patreon, Wednesday Night Workshop. Dave and Jax over here, Corruption Detector. So, that's just a little tidbit. I've been pretty busy. I just want to explain to people that the new office space is going quite well. I've ordered new tables. They'll be here soon, whenever they get shipped here. Other than that, set it for the setting up of the classroom. Other than that, most everything else is pretty much set up, ready to rock and roll. Everything's connected. I got the computers connected, internet's connected, TV's mounted on the wall. Got my office all pretty much all set up and books put away. Some of the office supply stuff, well, that's all in like a little back room now. Has its own little storage area, so that's nice. I haven't got it fully organized back there yet, but in due time. But other than that, pretty much ready to rock and roll at the office and waiting on, tables and chairs for the office, so for the classroom. And then I'll be having private classes through the office for local people, mostly for like the National Assembly stuff, to reassemble government de jure. But I'll be doing other law classes as well on a local basis. But so again, just thanks for the support on that, and I want to thank those that came and helped do the big move on Saturday last week. So that got moved in like 2 hours. So it happened pretty quick. We had sufficient enough bodies there to make it happen within 2 hours. Everything pretty much was moved from downstairs to upstairs, although in a big piles everywhere. But it took me about 2 to 3 days of myself working up there, and then my buddy Peter and Carrie came in one day there and helped tidy up the rest of it. So yeah, it's pretty much ready to rock and roll. I'm excited. No, there's not a lot of stairs. It's it's kind of an office building, but there is stairs to go up there, but it's still not very much. Of Granted, there's going to be some people that can't make it upstairs. But in the 6 years that I've been in that office building there, I haven't had one come in a wheelchair. I haven't had one come in that I wouldn't think they couldn't make it upstairs. So I think it'll be okay until I can outgrow that space. So yeah, I'm pretty excited about that. So other than that, I guess let's pick up kind of where we left off last week or week before. Hope everybody had a wonderful Christmas and Christmas week there and spent time with family and stuff, which I did, other than my mom and grandma, who was down in Arizona enjoying the beautiful weather they're having down there, 50s to 75 degrees. Lucky them. Snowbirds. All right, so let's get over here to Blackstone's Commentaries on the Law of England. Are these absolute rights? Now I can't exactly remember where we left off, so when I pulled this up, it kind of popped up a couple pages down, but I'm going to pick up right here at section 123, where I think it kind of goes into this, where I think I had left off. And so this is a repeat from 2 weeks ago. That's okay. But this is right where kind of need to start from here, essentially, because it gets right into the absolute rights here at the end of section 123. So we're going to start here. Now the rights of persons that are commanded to be observed by the municipal laws are of two sorts. First, such are due from every citizen, which are usually called civil duties. And secondly, such as belong to him, which is the more popular exception of rights or jura, like jurisdiction. Both may indeed be comprised in this latter division, and that's the exception of rights. For as all social duties are of a relative nature, at the same time that they are due from one man or set of men, they must also be due to another. Would those be like rights that we have in common? Like common law, common rights, common law, common sense law? That's what that would be. And where I've talked about this before, even in like Bouvet's Law Dictionary 1856 talks about rights are correlative to duty. So where one has a right, another man owes him a duty. So beings that we should all know our rights, because ignorance of the law, ignorance of our rights is no excuse. But given our situation and as society as a whole, worldwide even, we've been purposely dumbed down on purpose, right? We haven't been taught. There isn't anybody alive today that's been taught properly. They didn't, they kind of cut that out of our educational system. They've hijacked our education. So here we are in now 2024, one man out here trying to do a deep dive and research rabbit hole and find all this good stuff to read from and learn and teach from. Education. Knowledge is power, folks. So, let's get back to this. But I apprehend it will be more clear and easy to consider many of them as duties required from, rather than as rights belonging to, particular persons. Thus, for instance, allegiance is usually and therefore most easily considered as the duty of the people, and protection as the duty of the magistrate. And yet they are reciprocally the rights as well as duties of each other. Allegiance is the right of the magistrate, and protection the right of the people. Now there we go. Persons are also divided by the law into either natural persons or artificial. Now, this is where they pull from. It's a natural person. Well, you cannot define a person using the word person. And man is not a natural person. Even the Bible tells us to stay away from accepting these titles as persons. So, I am man, creation of God. Can anybody rebut that? Highly doubt it. It's impossible. So, let's get back to this. And understanding what it talks about here as a natural person is actually, are such as the God of nature formed us. Well, in reading Genesis 1:26 there, God created mankind. He did not create persons. But this is their word salad. So we have to even unlearn this and learn the true words. So rights of man come from the law of nature as a creation of God, from the laws of nature. Artificial are such as are created and devised by human laws for the purposes of society and government, which are called corporations or bodies politic. So, right here where we can make a very clear distinction is that one is a creation of God and the other is creation of man. It's called corporations. So, the rights of persons considered in their natural capacities, so the rights of man in nature, are also of two sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men, merely as individuals or single persons. So, as man. Relative, which are incident to them as members of society and standing in various relations to each other. That really just doesn't even make any sense. But the first, that is absolute rights, will be the subject of the present chapter. By the absolute rights of man, it says individuals, but I'm going to correct their language. By the absolute rights of man, we mean those which are so in their primary and strictest sense, such as would belong to man merely in the state of nature, and which every man is entitled to enjoy. So why are they using man here, but then they're still trying to use all this? This is word salad. Bar word salad, trying to trick the people into using these other words when we need to really use the word man. Is entitled to enjoy, whether out of society or in it. But with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce them. This goes right back to American Jurisprudence, Volume 15, Natural and Civil Rights, Section 2, that they have nothing to do with the establishment, support, or management of government. They pre-exist government. It doesn't have anything to do with government. Government doesn't have any authority over them. They don't have any authority to change them, alter them, deny them in any way, shape, or form. They are absolute and they are to be recognized at all times, whether in or out of society. Meaning when you become a member, a citizen, as defined by the Law of Nations, Book 1, Chapter 19, subsection 212, citizen is a member of a civil society who is bound to perform certain duties, like governor, lieutenant governor, sheriff. Those are members of the legislative, executive, or judicial branch who shall be bound by oath or affirmation to support the Constitution. That's Article 6, Clause 3. That's how that verbiage The definition of a citizen from the Law of Nations matches Article 6, Clause 3, members and bound. Those are the citizens. And this is also statuses. The other statuses we have here in America, in our republic, aside from citizen as members of the legislative, executive, and judicial, are the people or inhabitants. That's it. That's the only three statuses we have here in America. There's no such thing as national. Doesn't exist other than from the corporate bylaws created in 1878. So, anybody who tries to tell you, oh, you need to change your status, you need to change your political status to national, tell them to kick rocks. They don't know what the hell they're talking about. Can you cite the law? And I've run into this. I've talked to these people. Oh yeah, I've corrected my status. I'm a national. Yeah. Can you cite the law that comes from? And they can't. None of them even know what the hell they're even talking about. It sounds pretty, but it's not legitimate. It's not lawful. It's not correct. All right. So, now remember, these absolute rights have to do as man merely in a state of nature. See, a state is a state of being. But with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal should explain or enforce them. That's why we have supposed to have the common law side of our republic, where we have common law courts that start with a common law grand jury for deprivation of rights, for depriving a fundamental right. For the end and intent of such laws being only to regulate the behavior of mankind. Oh, now, this is where you get into personal jurisdiction. In our republic, who do they have the power to regulate? Who did we delegate? Who did we, the people, delegate power to regulate? Wouldn't that be commerce, corporations? Hey, Brother Rob, good to see you. Huh. We didn't give them the power to regulate the people. Oh, that's right. American Jurisprudence, Volume 16, Constitutional Law, Section 2. Again, 2017 update. So this is new stuff, right? This isn't like ancient American jurisprudence. This is like up-to-date stuff. Says that statutes are for government civil conduct. That's to regulate their behavior. The law of creation, which Hale versus Henkel talks about. That there's a reserved right in the legislature to do an investigation to see if the corporation and those people in there have exceeded the laws of its creation. Because those regulations apply to them when they get the business license for their corporation and incorporate in law. Then they're bound by those particular statutes. That's a contract. They have consequently no concern with any other but social or relative duties. Let a man therefore be ever so abandoned in his principles or vicious in his practice, provided he keeps his wickedness. Okay, I remember talking about this, but doesn't matter. His wickedness to himself. It does not offend against the rules of public decency. He is out of the reach of human laws. This is why our founders wrote the Fourth Amendment the way they did. The right of the people to be secure in their persons, businesses, private business, papers, houses, and effects. Right, that's right. You have to go get a warrant. You can't just arbitrarily demand our papers, please. That's the old Gestapo. Papers, please. Papers, please. No, we have the right to be secure. And that Hale versus Henkel backs that up. We have no duty, people in the private, they use the difference between a corporation and an individual, or individual and corporation. But the individual has no duty to open his books and papers on suit of the state, because he owes no duty to the state. He receives nothing therefrom except for the protection of his rights. Oh, that would be the intent of creating government now, isn't it? What's the intent of creating government? That to secure these rights, governments are instituted among men, receiving their just powers under the consent of the government. Oh, you have to have consent, and those powers have to be granted in writing. Must state with particularity what that power is that was granted. Oh, and you only have those powers that were granted. That's it. If it doesn't say you have that power, that means you don't have that power. But wait a minute. In order to secure the rights by instituting government, wouldn't the rights have to pre-exist? Oh, yeah, Hale versus Henkel talks about that too. Our rights are long antecedent to the formation of the state. That's right. Our rights existed before government was created. They're outside of government. Long before. And these absolute rights come from God, from nature. Laws of nature, which, the Supreme Court here ruled just last year, June of 2022, in the New York State Rifle and Pistol Association versus Bruin case. Well, all be darned, the right to keep and bear arms actually goes all the way back to the laws of nature as the fundamental right of self-defense. Uh-oh. I gotta reiterate this. This is the change. It's coming, folks. It's slow, but it's coming. Back to the common law. Back to the laws of nature. All right. But if he makes his vices public, though they be such as seem principally to affect himself, as drunkenness or the like, they then become, by the bad example they set, of pernicious effects to society, and therefore it is then the business of human laws to correct them. Well, only if there's a cause of action. But under the Roman civil law, a bill of attainder could say, hey, or bill of pains and penalties, say, hey, you can't be drunk in public. But the way our founders set up our form of government, you can be drunk in public. Just don't disturb the peace or breach of peace, which is assaults and batteries. And like I've said before, way back in the day when I first kind of started studying stuff and was reading the code, and I had found, way back in 1995, this whole scenario of like drunk driving, DUI stuff, didn't exist. But it said, the officer had basically had three options. Was to check them out and see if they were able to still make it home. They would follow them home to make sure they made it home safe. Now that would be protecting and serving the people. And if maybe he was just a little bit too tipsy, officer, maybe I'm not capable. Can I call somebody to come pick you up? Or can I give you a ride home? And then the other one was if they were so obnoxious drunk, couldn't get anything out of them, couldn't communicate very well, and definitely can't get them home if you can't talk to them, can't call anybody if you can't talk to them. Then they were supposed to take him to the drunk tank and leave him in there until they sobered up, and then give him a ride back to their car, or have somebody come pick him up. That's the way the Idaho Code read back in 1995-ish. Imagine that. So that's a clear distinction between the Roman civil law and the way they did things over there in England, and what at the time at the writing of this, how things were over there, which now we can see where in America, how we adopted some of these principles, like absolute rights of man, come from the laws of nature, as it is stated in the Declaration of Independence. To assume the powers of the earth, the laws of nature and nature's God, that we're endowed by our Creator with certain unalienable rights. Among these rights, among, not all, but among these is life, liberty, and the pursuit of happiness. So, very clear from the Declaration of Independence that it meant that we were to be free at all times. In the private, not out in the public. I get that. But the public is actually public servants. But we've all been taught, oh, as soon as you go outside, you're in the public. No. I'm not an elected official or appointed to a position of public trust under either the legislative, executive, and judicial branch. That's what makes public. Or public business. You have a business license. You open your doors to the public. It might be privately owned, but you're open to the public. And more specifically, if the products you're selling are imported, say from China, now you're in the public because now you're acting in commerce and your business can be regulated. Now that's the difference. Now say a man has a woodworking shop and everybody in town knows that he's a woodworker. Well, I'd like a new desk or a new coffee table. Okay, that's a private business. Doesn't have an open sign. He's not open to the general public, not open to the public. He's not funded by any taxpayer. He's not acting in commerce, foreign commerce, right? We're talking about just wood. And he creates something. One of a kind. That's truly private. Never is a business. Here, the circumstances of publication is what alters the nature of the case. Public sobriety is a relative duty. Sure, public service should remain sober while on duty, and therefore enjoined by our laws. Private sobriety is an absolute duty, which, whether it be performed or not, human tribunals can never know. So see, what we do in the private stays in the private. Even clear back here with Blackstone's Commentaries on Law of England. So it can't be any less than this today. We would only have further protections of our rights. We would not regress when it comes to our rights and the duties of government or public servants. Which, whether it be performed or not, human tribunals can never know. And therefore, they can never enforce it by any civil sanction. Civil, Roman civil law. But with respect to rights, the case is different. Human laws define and enforce as well those rights which belong to a man considered as an individual, as those which belong to him considered as related to others. For the principal aim of society is to protect individuals in the enjoyment of those absolute rights, which were vested in them by an immutable laws of nature. Immutable. No mutation. Okay, you don't get to alter them. And you don't get to have subject matter jurisdiction over them. You don't get to make legislation. It is out of the control, out of reach of government. But which could not be preserved in peace without that mutual assistance and intercourse which is gained by the institution of friendly and social communities. Hence it follows that the first and primary end of human laws is to maintain and regulate these absolute rights of individuals. Well, wait a minute. What do you mean, regulate? No. That's Roman civil law. Such rights as are social and relative result from and are posterior to the formation of states and societies. Oh, so what we're actually talking about is like, I don't know, the right to contract, or maybe political rights? Social rights? So that to maintain and regulate these is clearly a subsequent consideration. So let's get that, make sure that we get this completely separated, that absolute rights are off limits, before we even begin to talk about, there's these other rights that we can regulate. So that to maintain and regulate these is clearly a subsequent consideration, and therefore the principal view of human law is, or ought always to be, to explain, protect, and enforce such rights as are absolute, which in themselves are few and simple. And then such rights as are relative, which arising from a variety of connections, will be far more numerous and more complicated. Yeah. What a bunch of word salad that is right there. No. They're either God-given rights that comes from laws of nature, or they're not. And we don't get to regulate another man's rights, because we all hold the same right equally. And if we're all created equally, how is it that any man could have any authority over another man without his own consent, a contract of some sort or something? Would be completely illogical to even think that way. And therefore, if we ourselves, maximum law here, what I cannot do in my person, I cannot do through the agency of another. So if I can't deprive my neighbor of any of his fundamental rights, how in the heck would I delegate that power to, say, a state legislature to make legislation to regulate the right when I don't have that power? I can't delegate a power I do not possess myself first. Completely illogical. Again, are you of sound mind, or you little cuckoo up here? Okay. And therefore the principle of human laws ought to always be explained, protected, few and simple, and then such rights are relative, which arising from the variety of connections. Number 3 here. These will take up a greater space in any code of laws. See? Code. Roman civil law. Told you. Than the rights of the former kind. Let us therefore proceed to examine how far all laws ought, and how far the laws of England actually do, take notice of these absolute rights and provide for their lasting security. Now, notice it just exposed itself there when I said back up there, we're talking about civil, Roman civil law, the code. So they're still talking code over here, Blackstone is. So he's given recognition to the Roman civil law, even though in another place he talks bad about it. But that is the part of the Declaration of Independence was a declared act of tyranny, was fundamentally altering our form of government, subjecting us to a jurisdiction foreign to our form of government, unacknowledged by our laws, and subjecting us to pretended acts of legislation. That jurisdiction that they're talking about, a body of law, is the Roman civil law, which is opposed to the law of nations, the laws of nature, and the common law. So it's a totally different body of law as a fundamental law. Okay? So our choice of fundamental law here in America was the law of nations, the laws of nature, and the common law. The American common law, which was built through 1606 to 1776. We adopted our founders, original founders back in 1606 with the first charter of Virginia. Okay, they brought with them the English common law, but they only adopted those parts that were conducive to the public weal, starting from the very beginning. And I've tried to explain this to people that, essentially what was really going on was people were fleeing from Great Britain, fleeing from England, and wanted to settle here in America to get away. Again, back to the Magna Carta 1215, to get away from the Roman Catholic Church, Catholicism, as an ideology in the fundamental law, the Roman civil law, to get away from that and get into Christianity as an ideology. That's what was truly going on. So you want to talk about refugees fleeing tyranny? There you go. All right, so take note of the absolute rights and provide for their lasting security. The absolute rights of man, considered as a free agent endowed with discernment to know good from evil, and with power of choosing those measures to know good from evil, that's the first primitive laws of nature. One of the 6 primitive laws of nature is when man is properly organized, he knows the difference between moral good and moral evil. So that's what they're actually talking about here. The absolute rights of man, that we know, right? Discernment, knowledge, conscience, that we know good from evil. And with power of choosing. That's right. Free will, the right to freedom of choice. Liberty of conscience is religion. Those measures which appear to him to be most desirable are usually summed up in one general appellation and denominated the natural liberty of mankind. So there's a right. Natural liberty of mankind. Not of persons, but of mankind. Now I want to back up here because I was just seeing something in this footnote from footnote number 3 up here. The people of the American states have not been disposed to leave the protection of the absolute rights of individuals exclusively to the legislative bodies to which they have entrusted the making of the laws. Exactly what I was just saying. There is a very clear distinction between our American common law and the English common law. And here it is, being said by Blackstone, that the people of the American states have not been disposed to leave the protection of the absolute rights of individuals exclusively to the legislative bodies to which they have entrusted the making of the laws. We exempted that from the legislature. We did not give them subject matter jurisdiction over our rights, which backs up, the Law of Nations backs this up. Book 1, Chapter 3, Section 34, the question was asked, does the legislature have the authority to alter the fundamental law or the Constitution? The answer is no. We didn't delegate that power. We didn't want to be governed that way. We want public servants, not rulers. Our founders had experienced this for long enough and had the wisdom from history to say, you know what? No, we're tired of this crap. We're tired of being ruled over and being debt slaves and peonage through bills of attainder and bills of pains and penalties. No, we don't want that form of government. We don't like that kind of law. We want to live free as God intended us to be. Okay? So there you have it, in writing, that there's a very clear distinction between what they had going on over there in England and what we had going on here in America. We exempted our rights from any legislation. Nothing to do with the establishment, support, or management of government. Nothing. Absolutely nothing. None of their damn business. Because that's that natural liberty of mankind. This natural liberty consists properly in the power of acting as one thinks fit. Thinks. Right of conscience. Without any restraint or control, unless by the law of nature. That's that body of law. The law of nature. Being a right inherent in us by birth, and one of the gifts of God to man at his creation, when he endued or endowed him with the faculty of free will. But every man, when he enters into society, gives up a part of his natural liberty as the price of so valuable a purchase. Now, not in America. We did not. That goes back to that same thing. We're different in America. We do not give up any of our rights. We don't receive anything from government except for the protection of them. We didn't give them personal jurisdiction over man, and we did not give government subject matter jurisdiction over any of our rights. So it doesn't matter what legislation is made on any of the rights, including the Second Amendment, it's all void for any effect. Because there's nowhere in the Constitution that says that we delegated them power to make legislation regarding this particular right, known as subject matter jurisdiction. Imagine that. And in consideration of receiving the advantages of mutual commerce, obliges himself to conform to those laws which the community has thought proper to establish. Okay, now this is where I'll get into explaining the difference. Let's say you got a corporation. Let's get I like to use McDonald's. McDonald's. Now we have a corporation. They have the power to regulate corporations. We gave them that power. Okay? And so McDonald's orders food and all. Okay. Interstate foreign commerce, right? Some of it's imported, right? Clear out of the United States. I don't know if anybody knew that, but some of it is. Ugh. Gave up McDonald's a long time ago. But anywho, let's apply this here. Now let's say the corporation makes a policy that says you can't do this or, whatever. I don't know. How about you have to take this medical thing, what we call medical is a pharmaceutical drug, in order to continue to work here. No, that violates my right of conscience, my free will. You can't have a policy. Now we've got a problem. Now, technically speaking, we're supposed to go to the legislature for the redress of grievances and say, hey, McDonald's made a policy over here and is trying to apply their policy to me in violation of my right. They're depriving a fundamental right here. Well, that can't happen. That's where government's supposed to come in and go, well, no, McDonald's, you can't do that. And if you don't cease and desist with that policy, we'll revoke your business license. You won't be able to do business in our communities. Because it is a privilege to do business in our communities, not a right. Now, I know a lot of people disagree with me on that, but that's a fact. That's the truth. Hale versus Hinkle backs it up. that there's a reserved right in the legislature to do an investigation to see if it's exceeded the laws of its creation. If that power and that right didn't exist, then how is it possible that it's a right instead of a privilege? No, it's a privilege. Why do you have to have a business license? License is seeking permission. If it was a right, you wouldn't need a license. So there's another key. If you're truly going to be private, you don't need a license. But if you're going to be engaged in some form of foreign or interstate commerce, then yes, we, the people, require you to have a license so that if you do something wrong under that general welfare clause, you manufacture a product that causes injury, loss, or harm to the people, we can hold you responsible. And we can go so far as revoking your business license. Or even, I don't know, stop you from importing those goods at the ports. That's the general welfare clause. That's what they're supposed to be doing, is ensuring that nothing gets imported or manufactured here in the United States that may cause injury, loss, or harm to the people. That's the general welfare clause. That's the duty of Congress, to regulate commerce, to ensure nothing is manufactured and imported here in America that causes injury, loss, or harm to the people. There's many other nation states or countries that around the world that they ban certain things, certain food products even, certain ingredients in certain food products. Imagine that. Okay, so back over here. So now that we clarified the little bit of a difference here, and this species of legal obedience and conformity is infinitely more desirable than that wild and savage liberty which is sacrificed to obtain it. For no man that considers a moment would wish to retain the absolute and uncontrolled power of doing whatever he pleases, the consequence of which is that every other man would also have the same power. Well, lo and behold, then you'd be free. No man could dictate to you anything, so long as you do not cause injury, loss, or harm to your fellow man. Well, gee, that's the way our founders thought. That's the way they declared it in the Declaration of Independence. They were tired of living under the thumb of tyranny. And then there would be no security to individuals in any of the enjoyments of life. Excuse me? The right to keep and bear arms doesn't secure that? Maybe that's why we have the right to keep and bear arms, and that right comes from the laws of nature, the right of self-defense. So, all throughout history from 1606 forward, it talks about that we have the right to have arms while out on adventure. So when we leave the home and we go out on adventure, we want to go camping, we want to go for a walk, I don't know, we want to go float the river, you want to take your boat out. We have the right to have arms with us at all times. For what? Defense. Now, that's a fundamental principle that is different in America than anywhere else. Our founders recognized that right of self-defense from the laws of nature. We don't care what your Roman civil law code says. That doesn't apply here. That's not supposed to be here. It's not part of our Republican form of government. Kick rocks. Get that crap out of here. It's going away. I'm telling you right now, folks. Especially if I have something to do with it, which I might. I might have something to do with that. But we'll see. I know it's going to raise some eyebrows. Political, therefore, or civil liberty, which is that of a member of society, is no other than natural liberty so far restrained by human laws and no farther, as is necessary and expedient for the general advantage of the public. I somewhat agree with that. Right? Like we don't want the House of Representatives or Senate in there drinking away, getting drunk, trying to pass some legislation, do we? I think that would be common sense not to be drinking on the job. So there, but see, that legislation, that statute would only apply to them because they're bound by it. As discussed earlier, when you're in the private, that's none of government's business. It's not even any business of your neighbor. Unless you give cause. You cause harm or injury, loss, or harm to your neighbor. Now he's got standing. Okay? Hence, we may collect that the law, which restrains a man from doing mischief to his fellow citizens, though it diminishes the natural, increases the civil liberty of mankind. I totally agree with that. But that every wanton and causeless restraint of the will of the subject, whether practiced by a monarch, a nobility, esquires, or a popular assembly, is a degree of tyranny. Well, thank you for calling that out. You got that one right. Nay, that even laws themselves, whether made with or without our consent, if they regulate and constrain our conduct in matters of mere indifference, without any good end in view, are regulations destructive of liberty. Now, this is where we go back to the Bible, and we talk about the intent of legislation. What is the evil that is it intended to prohibit? Like if we made legislation that says, hey, while you're on the job in the House there, whether you're in the House of Representatives or in the Senate, you can't be drinking on the job. Okay, that's for the benefit of the advantage of the people, right? So we're paying these people to be there and to pass this legislation to regulate corporations and ensure that they're not causing injury, loss, or harm to the people. I'm thinking that's a pretty good thing to have there. So we actually get the work out of them. They perform the duties that they are to perform sober. Hey, like Chris and I used to talk about, once they punch the clock and they go home, they're off the clock. Now they have the same rights from nature as everybody else does because they're no longer on the clock. They're in the privacy of their own home. Now, out in public, I don't know. I kind of have a problem with elected officials, public servants. Let's just keep going with the alcohol thing. Intoxicated. Right? There's supposed to be a little bit higher standard of living. And set an example. The rest of us out here are just a bunch of inhabitants and, a bunch of sinners. And sinners do what sinners do. But for those in positions of authority, elected or appointed, they should be setting the example. But in moderation, right, as long as they're not getting drunk and belligerent, they're having a glass or 2 glasses of wine with dinner, or having a beer or 2 beers with dinner. I'm okay with that. But to sit there and, pound beer after beer after beer, and then start getting loud and obnoxious, no, come on, man. You're supposed to be setting the example out here as an elected official. I mean, you wouldn't want to run into the sheriff down at the local bar getting hammered. That just seems a little odd to me. I don't know about the rest of you, but it sure seems a little bit odd to me, right? Okay, we're making some good time here tonight. All right. The speech of legal obedience, conformity, and desirable that wild. We're down here again where we're at. Hence, we may collect the law. Let's see. Natural liberty so far restrained by human laws and no further. Yep. And is necessary and expedient for the general advantage of the public. Hence, we may collect that the law, which restrains a man from doing mischief to his fellow citizens, though it diminishes the natural, increases the civil liberty of mankind. I should mark my spot when I decide to go off track. From the degree of tyranny. Tyranny, that's it. Nay, that even laws themselves, whether made or with the intent, consent, regulated, and constrain our conduct in matters of mere indifference without any good end in view, are regulations destructive of liberty. Whereas if any public advantage can arise from observing such precepts, the control of our private inclinations in one or two particular points will conduce to preserve our general freedom in others of more importance, by supporting that state of society which alone can secure our independence. Thus, the statute of King Edward IV, which forbade the fine gentlemen of those times, under the decree of the Lord, to wear pikes on their shoes or boots of more than 2 inches, spikes, see, English language, Old English versus Newer English, Modern English, 2 inches in length, was law that savored of oppression, because however ridiculous the fashion then in use might appear, the restraining of it by pecuniary penalties could serve no purpose of common utility. Bills of attainder, bills of pains and penalties. You can't do that. So says the king. Let's see. By the statute of kings, which prescribes a thing seemingly indifferent, a dress for the dead, who are all ordered to be buried in woolen, is a law consistent with public liberty, for it encourages the staple trade, right, on which it great measure depends the universal good of the nation. Sure. But then, technically speaking, aren't you still depriving people of the right to choose how they bury their kin? Kind of a conflict between the previous statement. But there again, we're dealing with a dictator, a king, a ruler. For it encourages the staple trade. Okay, so that laws, when prudently framed, are by no means subversive, but rather introductive of liberty. But this is the key to this, folks, is in our form of government, our people at that time, in this time, and forward from here into 1776 said, no, we're not even going to allow the state legislature or Congress to make legislation like this. You're going to be narrowly construed to what your subject matter is and your personal jurisdiction. Okay? Let's see. For, as Mr. Locke has well observed, where there is no law, there is no freedom. Huh? But then on the other hand, that constitution or frame of government, that system of laws, is alone calculated to maintain civil liberty. Was it civil liberty or is it natural liberty? Which is it? See how they switch this up. But see, civil, every time you see civil, that's code. That's Roman civil law. Which leaves the subject entire master of his own conduct, except in those points wherein the public good requires some direction or restraint. Again, if you're a public servant, we can restrain your conduct. That's mind control, government. We control the minds of what we create, governor. Because no man is born governor. No man is born sheriff. Those are persons created by the people. Because remember, government is a figment of our imagination. It only exists on paper. It doesn't actually exist in reality, in the living physical realm. And it always takes a man or a woman to fill that position, to act. An actor who performs certain duties based on the office they were elected to or appointed to under an elected official. Okay? Time has his own conduct, except in the points of the public good. Yep. The idea and practice of this political or civil liberty flourish in their highest vigor in these kingdoms, where it falls little short of perfection, and can only be lost or destroyed by the folly or demerits of its owner. Owner? The legislature, and of course the laws of England, being peculiarly adapted to the preservation of this inestimable blessing, even in the meanest subject. Very different from the modern constitutions of other states on the continent of Europe, and from the genius of the imperial law, which in general are, man, there's a lot of footnote stuff going on there, which in general are calculated to vest an arbitrary and despotic power of controlling the actions of the subject in the prince or in a few grandees. And this spirit of liberty is so deeply implanted in our Constitution and rooted even in our very soil that a slave or Negro, the moment he lands in England, falls under the protection of the laws and so far becomes a free man, though the master's right to his service may possibly still continue. So even in England at that time, they're saying, hey, because he's still a man, right? The absolute rights of every Englishman, which, taken in a political and extensive sense, are usually called their liberties, as they are founded on nature and reason, so they are coeval with our form of government. Though subject at times to fluctuate and change, their establishment, excellent as it is, being still human. At some times we have seen them depressed by overbearing and tyrannical princes, at others so luxuriant as even to tend to anarchy, a worse state than tyranny itself, as any government is better than none at all. I don't know. I would disagree. I almost think we'd be better off without government at all. And people just mind their own damn business, and when somebody sticks their nose where it doesn't belong, it gets knocked off. Now, keeping in mind, with the right of self-defense, and everybody gets to have arms, so even the weakest of men, or women, can effectively defend themselves from a giant. Like David and Goliath. One stone took out Goliath. See the principle there? So it wouldn't be anarchy now, would it? That would be social justice. We take care of our own, thank you very much. Leave us alone. But see, this is the way our founders thought too. Well, what exactly do we need government for? I mean, there's definitely some things that we need to ensure that we're able to carry on commerce with the protection from pirates. Now we're talking. But the vigor of our free Constitution has always delivered the nation from these embarrassments. And as soon as the convulsions consequent on the struggle have been over, the balance of our rights and liberties has settled to its proper level, and their fundamental articles have been from time to time asserted in Parliament as often as they were thought to be in danger. You mean when you had a grievance, you filed a petition with the legislature or with Parliament? Yeah, that's all right. That right of petition, its origin is from the Magna Carta of 1215. That's how long this right to petition the legislature for the redress of grievances has been around. 800 some years now. 800 plus years. So if any of our rights, that we thought any of our rights were in danger, we should be immediately, petitioning. First, by the Great Charter of Liberties, which was obtained sword in hand. Yeah, the Great Charter of Liberties, that would be the Magna Carta of 1215. Okay, so here it is in writing, exactly what I've been telling you folks. What the Magna Carta is, a Great Charter of Liberty. So first, by the Great Charter of Liberties, which was obtained sword in hand from King John, and afterwards with some alterations, confirmed in Parliament by King Henry III, his son, which charter contained very few new grants, but as Sir Edward Coke observes, was for the most part declaratory of the principal grounds of the fundamental laws of England. You mean like rights as the law? The common law? The law that is common to all? These absolute rights from nature? Was the fundamental law of England? So says Sir Edward Coke. That was his observation. Afterwards, by the statute called Confirmatio Cartiarum, whereby the Great Charter is directed to be allowed as the common law. Gee, it's almost like I know what I'm talking about. All the judgments contrary to it are declared void. Would that be like Article 6, Clause 2, that anything that comes in conflict with the Constitution is void for any effect? Or proper verbiage is, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary are not withstanding. They have no standing. From the day they were created, that's where you get back to Marbury versus Madison. You got your case law behind Article 6, Clause 2. The supreme law of the land already says this. But here's your case law, your stare decisis, that backs it up. Anything that comes in conflict with the supreme law of the land is void for any effect from its inception. Void ab initio. Not from the day you go to court and brand it unconstitutional. From the day in time that it was enacted, the day it was created. It's void. Bam. No man is bound to obey it, and no man is bound to uphold it, like a judge. Okay? Copies of it are ordered to be sent to all cathedral churches and read twice a year to the people. Does anybody know of any local church that they go to that, I don't know, might read the law to us twice a year? And the one they're talking about here is the Magna Carta, the common law. So everybody knows the law. Why do you think I've been out here for the last frickin' 6 years, folks, trying to educate my fellow man on what the law actually says as it is written? I know there's been lots of trolls, a couple of bar members that have tried to disparage me and call me sovereign citizen crap, which I've totally debunked sovereign citizen. It doesn't exist. It's a CIA op, FBI op, garbage. Okay? They're the citizens, public servants, or citizens, and we, the people, are the sovereign. So sovereign citizen, you're right. It doesn't go together. We, the people, are the sovereign. We created government. Those in service to the people are the public servants, or citizens. They do give up some of their sovereignty in the exchange for the emoluments of the office. You know, those advantages, profits, and gains. They have to do what we tell them to do. They don't get to think for themselves. They're servants. We're the masters. And servants never get to dictate to their masters what their scope and authority or their duties to perform are. And see, there is a clear distinction between a servant and a slave. Servants get paid. Slaves, in essence, do not. All judgments contrary are declared, but copies of an order, and sentence of excommunication is directed to be as constantly denounced against all those that by word, deed, action, or counsel act contrary thereto, or in any degree infringe it. So they had a fundamental principle back then. You were excommunicated from the church. Now, the reason why this is really good to understand is because that's how things were back in the day. Everything was done through your local church, the town church. Everybody in your community, I wouldn't say everybody, but most everybody went to church that once a week there. But it was also the schoolhouse. It was also where the common law grand jury was at, where your petite jury came from. That was a jury of your peers in your community, from your vicinage. Which was closely followed... wait. Infringe it. Next, by a multitude of subsequent corroborating statutes, Sir Edward Coke, the first think, reckons 32, from the first Edward to Henry IV. Then, after a long interval, by the Petition of Right, which was a parliamentary declaration of the liberties of the people, assented to by King Charles I in the beginning of his reign, which was closely followed by the still and more ample concessions made by that unhappy prince to his parliament before the fatal rupture between them, and by the many salutary laws, particularly the Habeas Corpus Act. Huh. Whoa. More common law stuff. Before America? In the English common law? Passed under Charles II. Now, what is the habeas corpus? Hey, bring the body. Now, bring your books and papers, bring the body, corpus, without haste, right now. And whoever has the man, whoever caused the man to be arrested, they have to prove it right there on the spot. And if they can't, the judge is to release them from confinement. Right now. Any restraint that's unlawful. This is where justice is to be without sale, denial, or delay. We're supposed to be using the habeas corpus. These are writs from the common law. You want to talk about original jurisdiction. Common law shall not be otherwise reviewed in any court of the United States except for pursuant to the rules of the common law. That's the 7th article of the Bill of Rights, or 7th Amendment. These writs are from the common law. This is a rule of the common law. So the common law dictates what you can make an arrest for. If they've made an unlawful arrest, you're supposed to be able to use the writ of habeas corpus, go directly before the Supreme Court, because they're the only court that's vested with original jurisdiction, because all other courts are created by the legislature. That's right. So that's one of them common law writs that can only be suspended if you're engaged in an act of rebellion or in time of war. If you're in the military, you can't use writ of habeas corpus because now you've bound yourself to admiralty jurisdiction. Manual for courts martial? That's a court martial. That's admiralty jurisdiction. Admiral. Not to be confused with maritime law out on the sea, in trade, commerce. No, we're talking about in the military. Okay? Two different jurisdictions. But one overlays the other, honestly, the admiralty jurisdiction and maritime law. You know, admiral of a ship, of the Navy. It's a rank. Okay. Passed under Charles II. To these succeeded the Bill of Rights, or declaration delivered by the Lords and Commons to the Prince and Princess of Orange. Oh, would that be that English Bill of Rights, 1689? Why do they say in here, 13th of February, 1688? Huh. And afterwards, enacted in Parliament, when they became king and queen, which declaration concludes in these remarkable words, and they do claim, demand, and insist upon all and singular the premises as their undoubted rights and liberties. Okay, so there's a Bill of Rights or Declaration of Rights that we can still cite today. In fact, in the New York State Rifle and Pistol Association versus Bruin, they cited the English Bill of Rights of 1689 when talking about, the part in there about the right to keep and bear arms, that the Protestants have been deprived. That was one of the grounds for the little war they had there at that time, and the change of the prince and princess. That's right. because they tried to take their arms from them too, while the papists remained armed. That was in the New York State Rifle and Pistol. So don't tell me that we can't cite the English Bill of Rights of 1689. Because they sure did. In fact, they went even further back and cited this, Blackstone's Commentaries on the Law of England, which goes much further back. I mean, they're talking about the Magna Carta, the Great Charter of Liberty from 1215 here in Blackstone's Commentaries on the Law of England. So don't tell me it doesn't even go further back than 1689. It goes all the way back to 1215. And then the Aziz of Clarendon of 1166 for the right to trial by jury, because that's what Aziz is 12 men. That's the origin of the right to trial by jury, 1166, prior to the Magna Carta. Whoops. All right. And they do claim that recognizes all the singular rights, liberties ascertained and claimed in the Declaration to be true. All right. Premises. And the Act of Parliament itself recognizes all and singular the rights and liberties asserted and claimed in the said declaration to be the true, ancient, and indubitable rights of the people of this kingdom. Lastly, these liberties were again asserted at the commencement of the present century in the Act of Settlement, whereby the crown was limited to his present majesty's illustrious house. And some new provisions were added at the same fortunate era for better securing our religion, laws, and liberties, which the statute declares to be the birthright of the people of England, according to the ancient doctrine of the common law. Well, that would be the ancient doctrine of the common law comes from the Saxon, which I've covered previously, from this book right here, discovering the true origins of the common law, is actually from the Saxon, Anglo-Saxon, the good Christian Protestants, the Saxons, is maxims of law and customs. That's the origin of the common law. Do not be deceived and listen to these members of the bar out there that will try to tell you, the common law is stare decisis, case law. No, that would be false. It's a half-truth. Anytime that somebody fought over certain rights or whatever, and the judicial branch ruled on that, that did come as part of the common law. But even, what's her name out there? The constitutional attorney, supposedly out there, Chris Ann Hall. She even said the same thing I've been saying for years, a few years back. That the case law is the law of the case, and it only applies to the parties to the case. Why? Because that's a resolution, that's a contract. It's binding upon the parties. It is not binding upon anybody else. At all. Now, when you're talking about constitutionality challenges, and say, like, all the way up to the Supreme Court rules on it, then yes. But all they're doing is giving their opinion on facts of law. And they're interpreting whether or not something that the legislature made or the executive branch did was unlawful and unconstitutional, and declaring it as such. Kind of like what they did in the New York State Rifle Pistol Association versus Bruin case. They struck down all legislation nationwide that has anything to do with us seeking permission to carry, either open or concealed now. I did read that in there. So, as of June of 2022, in the New York State Rifle Pistol Association, there shall not be any legislation out there in any of the states of the Union that says you have to seek permission to conceal carry. We actually changed our code in Idaho here a few years back, and that was for only in city limits. Otherwise, outside of city limits, you didn't have to have a permit to carry concealed. The change was changing it from outside of city limits to now inside city limits. We don't seek permission to conceal carry. But, again, according to the ancient doctrine of the common law, and this was a statute that declares to be the birthright of the people of England. Thus, much of the declaration of our rights and liberties, the rights themselves, thus defined by these several statutes, consist in a number of private immunities. Private immunities? Which will appear from required by the laws of society to be sacrificed to public convenience, or else those civil privileges which society hath engaged to provide in lieu of the natural liberties so given up by individuals. So, there again, we didn't do that. Period. What's up, Rob? Yep, no subject matter jurisdiction to begin with. Whew. Okay, now we're getting down to time. These, therefore, were formerly either by inheritance or purchase the rights of all mankind. Well, these rights come from God, so from birth, the birthright of the people. So, I guess he's just kind of saying before all this stuff, right? It's residuum or residual of natural liberty. These, therefore, were formerly either by inheritance or purchase the rights of all mankind. But in most other countries of the world, being now more or less debased and destroyed, they at present may be said to remain in a peculiar and emphatical manner the rights of the people of England. So, yeah. And this is why even the Magna Carta says that it's for all English-speaking nation states. All English-speaking nations. So if you speak English today, the Magna Carta applies, if that's your national language. Let's see. These may be reduced to three principal primary articles. The right of personal security, the right of personal liberty, and the right of private property. Because as there is no other known method of compulsion or of abridging man's natural free will, but by an infringement or diminution of one or other of these important rights. The preservation of these inviolate may justly be said to include the preservation of our civil immunities in their largest and most extensive sense. Now, it's not the right to travel, folks. Read and learn the proper words to use to claim and exercise the right. The right of personal security consists in a person's legal and uninterrupted enjoyment of his life, his limbs, his body, his health, and his reputation. Life is the immediate gift of God, a right inherent by nature in every individual and every man. And it begins in contemplation of law as soon as an infant is able to stir in the mother's womb. Oh, that means it's murder to abort. Unless for medical reasons. Think about that. And that's what the DOJ came out. That's that video I shared on Telegram from the DOJ, specifically talking about Idaho, how they sued the state of Idaho and made it, hey, back to the common law. Abortion is unlawful. It's murder, with the exception for medical reasons to save the life of the mother. That's just common sense here, guys. But even then, if you're walking with God, you wouldn't die from childbirth because God would protect you from that. Maybe that's your sentence of death. I don't know. But in our civilized society, we have said that, okay, it's not murder as long as it's to preserve the life of the mother. Because, here's the other thing. What happens is just a bad thing. I don't know. And you have the abortion, and the mother heals, and, the wife heals, and the husband and wife decide to try again, and they're very successful, having 1, 2, 3 kids after that. But if you didn't save the woman's life, there wouldn't be the ability to try again. But see, that choice ultimately should be between the husband and the wife and their doctor, not government. And government shouldn't allow businesses, corporation, to conduct their business to provide abortions. Free will, free willy. Okay, we're still talking about personal security here. The right of life. For a woman is quick with child, and by a potion or otherwise killeth it in her womb, or if anyone beat her, whereby the child dieth in her body, and she is delivered of a dead child, this, though not murder, was by the ancient law homicide or manslaughter. It's still a form of murder. It's still, yeah, the ancient Roman civil law, sure. But the modern law doeth not look upon this offense in quite so atrocious a light, but merely as a heinous misdemeanor. Now, in Treatise on Arrest and False Imprisonment, it talks about that being a capital offense. Because back in the day, homicide, manslaughter, it didn't matter. Those were capital offenses. You were sentenced to death. Not to jail, but to death. You were hung. Because remember, we're supposed to be gifts of God. So if an infant in vitris mir, I wish I could speak Latin and understood it, or in the mother's womb, that's probably what that means, in the mother's womb, is supposed in law to be born for many purposes. See, that's the thing. We don't know what their purpose is. It is capable of having a legacy or a surrender of a copyhold estate made to it. It may have a guardian assigned to it. And it is, I know we're running out of time, but I want to get to the next part. And it is enabled to have an estate limited to its use and to take afterwards by such limitations as if it were then actually born. And in this point, the civil law, Roman civil law, agrees with ours. Now, see, there you go. Right there, Blackstone's making a very clear distinction between the Roman civil law and the English common law. As two different bodies of law. Fundamental law. A man's limbs, by which for the present we only understand those members which may be useful to him in fight, and the loss of which alone amounts to mayhem by the common law, are also the gift of the wise Creator, to enable him to protect himself from external injuries in a state of nature. Isn't this what they were talking about? The right of self-defense from nature in New York State Rifle and Pistol Association versus Bruin? Yep, this it. To these, therefore, he has a natural inherent right, and they cannot be wantonly destroyed or disabled without a manifest breach of civil liberty. Both the life and limbs of a man are of such high value in the estimation of the law of England that it pardons even homicide if committed self-defense, in self-defense, self-defendo, self-defendiendo, in self-defense, or in order to preserve them. For whatever is done by a man to save either life or member is looked upon as done upon the highest necessity and compulsion. Now, the maximum law here is that what a man does in his defense is to be considered legal. Therefore, if a man through fear of death or mayhem is prevailed upon to execute a deed or to do any other legal act, these, though accompanied with all other the requisite solemnities, whatever, may be afterwards avoided if forced upon him by a well-grounded apprehension of losing his life or even his limbs in case of his non-compliance. And the same is also a sufficient excuse for the commission of many misdemeanors, as will appear in the 4th book. The constraint a man is under in these circumstances is called in law duress, from the Latin durities, of which there are two sorts: duress of imprisonment, where a man actually loses his liberty, or which we shall presently speak, a duress per minus, where the hardship is only threatened and impending, which is that we are now discoursing of. So even if it's, this even goes back to the case like John Bad Elk and blah, 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 which was a man who was being harassed by some sheriff deputies because the sheriff wanted to talk to him about discharging his firearm there in the city, which he just wanted to talk to him. There was no warrant. There was no charges against him. And, he the first time they came by and said, look, I've got to take care of my mom. I've got to take care of the farm. When I get done with that, I'll go see the sheriff. Well, they came back a little bit later, and he wasn't done with his chores, and they tried to lay hands on him, and he pulled his arms in self-defense, shot and killed the two deputies, and the court ruled, no, he acted in self-defense. They had no warrant for arrest. Oh, gee, I don't know. How could the Supreme Court be wrong? Because they understood back then, because that was a real early case in our history. But it's a very good case to read, and I'll try to get that out there when I remember the full citation and find that. Maybe somebody watching right now or later might remember it. I thought that I looked for it in my downloads, and I didn't have it. It might be in one of my tabs still, up on my computer right now, of the, 150 tabs I have open. But, man, there's so much more good stuff here. So we're going to leave off at 131. Okay, folks? In fact, I'm going to make a little note of that right now for next week. $131. Yeah, there's so much good stuff here. A fear of battery. We're being beaten. Though never so well grounded, is no duress. Neither is the fear of having one's house burned or one's goods taken away and destroyed. Because in these cases, we're going to come back to this anyway, but I kind of want to finish that real quick. And I'm going to jump down. Should be threatened, be performed. A man may have satisfaction by recovering equivalent damages. Now, that's different than what we have said here. We said no. We have the right to defend life, liberty, and the pursuit of happiness, our property, all 9 yards, with arms. We made it very clear at all times. But I want to jump down real quick because of the one, as I like to just point out, and I'm still going to cover it. We'll go back to 131 next week. Is the law of personal liberty. And this is part 2. Next personal security law asserts that preserves personal liberty of individuals. Personal liberty consists in the power of locomotion, of changing situation, or moving one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint, unless by due course of law, which is due process of law from the law of the land. Now, that, coupled with the right to acquire, possess, and utilize personal property how we see fit. It's an automobile, a carriage, car. It's not a motor vehicle. 2 totally different things. One's used for commerce, the other's private property, personal property, and we're exercising the right of personal liberty, which this is in Bouvet's Law Dictionary, 1856, which cites this right here. So a lot of people think it's the right to travel, when in fact, from the law, the letter of the law, it is personal liberty is the right, which consists in the power of locomotion. Choo-choo, vroom vroom. That's what locomotion is. You know, that's why they call the train the locomotive engine, internal combustion engine. Choo-choo, vroom vroom, are both internal combustion engines. Okay? So, just wanted to touch on that as a precursor for next week. And that was at section 131. Because this is so important to learn these basic fundamental rights, folks. It really is. Yeah, that's the next thing I was going to talk about. Is I have trial tomorrow morning, starting at 8:30. A second. They're trying to try me twice for the same crime. So, we'll probably talk about that next Monday a little bit, whatever I post out there. But again, it's already a done deal. We went to trial on November 9th, and they lost. Even with a 6-man jury, which is unlawful and unconstitutional. Again, folks, the long game. Document, object. Document, object. Create the record. Now, I can prove that I gave them notice. I afforded them the opportunity to do the right thing, and they didn't. Their asses are mine. Make no mistake. Just like it's been said before, we can't stop them from committing the crimes. Now, in this instance, once they start the trial tomorrow morning, now I'm being put in double jeopardy, and that completes the crime. Okay? All right, folks. One last thing there. Well, actually, I'll do two different things. I'll have to pull a... Oh. Let's go to... my website here. I want to just kind of push that out there. Obviously, if you're watching right now, you're on your favorite social media, but Facebook, Telegram, YouTube, and Rumble. There's the 4 links to the main social medias that I broadcast live on. Telegram is my basically number one go-to, where I do most of my postings and that stuff on. Okay. And then this one here is the P for Patreon. You want to get in on Patreon. Now, starting January 17th, I'm going to kind of start a new, kind of like a new series here for Wednesday night workshops. And I'm going to go through my case, document by document. I'm going to explain things and what they mean, what it's all about. Step by step, what I have already done and where I'm going. But these are going to be real short classes because I don't want to overwhelm people. Basically, it's kind of going to be one document at a time. So Wednesday night workshops, essentially the class portion of it will be fairly short. This is coming under advisement on a couple different people. So need to shorten this stuff up to make it a little bit more palatable. Yeah, I did a notice of special appearance. I did an affidavit that I'm not the name, the motion to dismiss, challenging personal jurisdiction, subject matter jurisdiction, defects in the prior proceedings. He didn't take me to jail. He didn't get a grand jury indictment. Listen, folks, I know what I'm doing. I know what I'm talking about. Okay? So, this is all just, it's setting them up. I'm following due process of law. Because I'm not above the law. I have to follow due process of law. I have to remain in honor too. And not only that, the key part of this is, how in the heck am I going to prove that I followed due process of law by giving them notice and affording them the opportunity to do the right thing, and they didn't, if I don't have the proof? Where's the evidence? That's the key to all this. This is the long game. But you have to know the law first, right? You have to know what your rights are. You have to know what the limitations of government is. And then you have to know how to do the paperwork and put them on notice. Okay? That's the key to all this. That's the key to knowledge. Knowledge is the key. Knowledge is power. If you don't have this knowledge, you have no power. So there's that. And just want to point out the library tab, where I recommend people start reading. Treatise on Arrest and False Imprisonment is a very good, very, 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 very good start. It's actually based on a traffic stop. And it has, document templates in there for a summons, a complaint, and a memorandum of law already built into this book. Okay? Now, the other thing is the National Assembly. Okay? Every Thursday. Conference call info right there. If you don't have free conference call, I highly recommend you download it and install it, whether it's on your phone or it's on your desktop computer. If you need help with that, here's a tutorial video for your desktop. Here's a tutorial for your smartphones. on YouTube. Okay? And then right here is the link that you click on once you get it installed. Otherwise, you can just call in directly from your phone, but there may be charges. Okay? Some not all of them anymore, but there still are some out there that charge per minute. So, highly recommend. I mean, if you're on a smartphone as it is, just download the app. It makes it super simple. And then once you install the app, whether it's on your desktop or on your phone, the next time you bring up free conference call and you've already clicked on this once, it'll be saved right there in the drop-down box. And you just join. So you don't even have to come on here. Every Thursday night, 6 p.m. Pacific, 9 p.m. Eastern. Goes for 2 hours. Okay? Been doing a lot of really good education on there the last 2 months even. Really been enjoying being on there when I can get on there. Most of the time I've been making it. Because there's some little tidbits that I'm picking up that I didn't know. I love Bill's presentations there, his PowerPoints, and you got Oscar does something. I did one with Oscar on the Citizens Manual, the military training manual. I did go over Lysander Spooner's the very first portion there of his essay on the right to trial by jury. But this is what we need to do, folks. We need to reassemble government de jure and take back our power and take control of our government. Because all political power is inherent in the people, not American state nationals. It's inherent in the people. The people need to unite. We need to come together. Okay? Get on these calls and get connected with your state coordinators or moderator, whatever their communications secretary, whatever they have set up. For me, I'm the coordinator for Idaho de jure at protonmail.com. If you're interested in Idaho, you are in Idaho. Hey, Scrimshaw. Good to see you. I've been busy reading. I actually haven't been paying attention to a lot of the comments out here. Yeah, the lectures on National Assembly, they've been pretty darn good. Other than that, Happy New Year's, folks. It's going to be a great year. It's going to be my turn to go after them. And we'll see what happens. So God bless everybody out there. Again, 1/17, January 17th, Wednesday night workshop. So that's tier 3. Okay, you'll need to be in tier 3 to get into Wednesday night workshop. So if you want to get in on this right at the very beginning of it, it would behoove you to get in there and get subscribed. Okay? January 17th. All right. God bless everybody out there. God bless America. God bless the world. Thanks to everybody who's helped supported so far in the past and still is currently supporting through Patreon. That's basically the only way I can do things unless you send me a donation through the snail mail at the office, which is still the same address except for moved from Suite C, Charlie, to Suite G, as in golf. All right. So anybody would like to just send regular donations through the mail to me, It's the same address. You want to do postal money order, regular money orders, cash wrapped aluminum foil, gold, silver coinage. Send that over to the office, please. Greatly appreciate it. All right, folks. Have a wonderful night. Happy New Year's again. And we'll see those of you that are on Patreon for Wednesday night workshop. We'll see you Wednesday night. And for the rest of you, we'll see you next Monday Night Law. God bless everybody.